Welcome back to this YouTube channel. Today we're going to pass through legal writing. Of course, the Bible says that you reap what you sow. So it's time for us to reap. And I think it has been a journey, and this is the last video on this YouTube channel for this semester. But please, if you have not subscribed, please consider subscribing because next semester we shall be analyzing both workshops from the general intake, and also we continue with the September intake. So please, it's at your advantage that you subscribe and also put on that notification button so as you can get every update of any video that you are going to be posting effective next semester, where we shall be preparing for oral exams as well. So I believe that this channel, if you follow it, it's going to simplify oral exams for you. So having said that, let us look into legal writing. And basically, legal writing is a category B subject where we have a test very soon. So importance of legal writing. So writing serves as a test of sort, a critical process that clarifies ideas. Language is not only a tool but an integral part of the thinking process. As Asa Linton states, that the importance of effective legal writing in law practice, despite its importance, legal writing is often criticized for its complexity, verbosity, and lack of clarity. So basically, here they are trying to tell you that writing is part of the thinking process. So if you have good thinking practices, then you're going to be a good writer. So criticism for legal writing and lawyers, basically we have basic grammar. We tend to use a lot of words which are complex, which an ordinary person cannot understand. So causes of poor writing in law, we have style. Professionals develop unique codes and jargon, but excessive reliance on legalese obscures meaning. So you find that in legal writing, they don't emphasize that you use clear and simple and straightforward words. They don't want those big words which scare off clients. So they want you to use the words which can be easy to understand, simple, and straightforward. So clarity of thoughts, poor thinking often results in poor writing. So basically, a bad thinker also is a poor writer. Then 3, ignorance and stubbornness. Misuse of legal terms and legalese persists due to lack of awareness or unwillingness to change. So we see like most of the lawyers use a lot of strong words to intimidate clients, most especially in notice of intention to sue. You find that the lawyer is saying that I'm going to throw all the legal machinery on you, and those words are not always the best in legal writing, because they make even the opposite client to have a hard heart, and things which would have been finished in alternative dispute resolution. Then exhaustiveness, lawyers are trained to leave no detail unexplored, leading to verbose writing. So you find that you are putting a lot of words on a sentence which do not add any meaning but only consume space. So materialistic pressures, competitive environments, and financial incentives can prompt unnecessary complexity. So some lawyers tend to use hard words in order to confuse clients, so as clients cannot understand their language. Then historical precedent, a tendency to adhere strictly to precedent discourages innovation in writing style. So most of the legal work is structured. So where the work is structured, that means there is limited thinking. Then majestic ritualism, the majesty of the law is sometimes upheld through unnecessary complex languages. Technological impact, tools like typewriters and computers may influence how documents are structured. Then institutional pressure, business demands can lead to rushed and unclear drafts. For example, if you are because we have timelines, so the fact that we are acting in timelines, sometimes you find that you have to draft a document and that's the deadline day. Then cultural disconnect, limited knowledge of broader linguistic and cultural context can hinder clarity. So improving legal writing, of course, focus on clarity in word choice, use precise and concise language, organizes structure, utilize headings, subheadings, and bullet points for clarity Then paragraph and subparagraphing break content into manageable parts to improve readability. And effective punctuation, use punctuation as a tool to aid comprehension and interpretation. So these are some of the ways you can improve your legal writing by clear choice of words, by organized structure, by proper paragraphing, and effective punctuation. So we have a case study, improving sentence. So you should avoid unnecessary words which are repetitive and also which are repetitive and does not add any meaning to the sentence but only consumes space. So for example, you can have problems in the sentence include repetition, the word "or" is overused, unnecessary detail, many phrases can be simplified, length, the sentence is excessively long, hindering comprehension, ambiguity, the sentence lacks clarity in its legal implications. So basically, when you are given a big sentence that you are required to correct, you focus on those things. Are there repetitive words? Is there unnecessary detail? Is the length too unnecessary? And are the words too ambiguous? So you have to focus on simplicity, being specific, and also providing clarity. So specification can include condense multiple terms like noxious waste product into harmful waste. Specificity include replace vague phrases like any person to include to be specific, or any anxious waste product, raw sewage, oil, so dust or other matter or thing with a broader clear term. So you have to be, for example, where you're saying that a man, a female, a child, you can say any person. So that's what they are trying to mean here. So conclusion. So improving legal writing requires commitment, plain language, clear thinking, and structured presentation. So by prioritizing readability and accessibility, lawyers can communicate more effectively and foster greater public trust in legal documents. Then let us look at key elements of effective writing style. 1, audience. So when you're writing, you must first consider your audience. Writing style must be tailored to the intended audience. For instance, legal writing offers from creative writing and textbooks differ from other writing. Then punctuation. Proper punctuation enhances clarity, while poor punctuation can confuse readers. Use punctuation wisely to guide the reader's understanding. Then choice of words. Use words which are not vague, which are polite. Don't use words which will intimidate or annoy your audience. Then sentence construction. Use the active voice for direct and concise sentences. Passive, the truck was overloaded by the workmen. Active, the workmen overloaded the truck. So they are saying that use active instead of passive. So passive is the truck was overloaded by the workman, and the active is the workman overloaded the truck. Then conciseness, avoid wordness and redundant words, for example, which are very wordy. Then overall presentation, break content into manageable sections using headings, subheadings, or breakpoints. So improving simplicity and clarity, use simpler words, words which can easily be understood. Use of dictionaries, refer to authoritative dictionaries to ensure proper use of current recognized meanings of words. Then technical terms, use technical terms like testator or habeas corpus in contexts where their specific legal meaning is essential. But always avoid using technical terms, but of course it goes down to who you are writing to. Then example of simplifying wordy legal writing. So original sentence, due to the fact that the contract was breached, the claimant filed a lawsuit against the defendant. Revised sentence, because the contract was breached, the claimant sued the defendant. So due to the fact that the contract was breached, the claimant filed a lawsuit against the defendant. And then the revised sentence can be because the contract was breached, the claimant sued the defendant. So you see, they all mean the same thing, but the second sentence is clear and straightforward. Then we can have an example of a vague sentence. Until recently, the policy allowed certain exemptions. Specific sentence. Until 2020, the policy allowed certain exemptions. So you have to be specific. So summary of good writing, you have to be concise, clarity, structure, active voice, and punctuations. So types of writing, you have exposition writing, which explains, informs, or defines. Example include legal texts and manuals. Then you have narration, which tells the story, example, personal accounts or case histories. We also have argumentation, which persuades, example, legal submissions or court arguments. Then you have description, uses sensory details, example, portraying scenes in legal or investigative reports. So principles of legislative drafting, we have determination of policy. Policymakers decide the purpose of the law. Then creation of the legislative scheme. Parliament Council organizes the law's framework. Then drafting sentences. Parliamentary Council express the policy in legal terms. So essentials for drafting clear legislation: they must be short, simple sentences. For example, a person shall not enter a swimming pool unless wearing swimming costume. And then components, we must have a legal subject who is obliged or empowered. Example, the editor of a newspaper shall file a declaration. Then predicate, what must the subject do? Example, shall file a declaration. Circumstances, when does the law apply? When any person publishes a seditious article. Conditions, the term under which actions are required. Example, if the appellant complies with the sections 24, the court shall order payment. So basically here, they are taking you through the process of legal drafting, because sometimes they can tell you to draft a law on certain things, and this is what you must ensure that your section or your legislation has. First and foremost, it must stick the principle of legality, but also you must show who and what circumstances will he be liable, and if he has done what. Basically, that's what they are trying to explain here. So the drafting guidelines, there must be a legal subject. The subject is usually a person or entity obligated to act. Then use of and versus or. So example, a doctor and a nurse shall be presented at birth of a child. Shall be present at the birth of a child. So or the managing director or the secretary shall file the report. So here they are giving you scenarios where they can use and or, because when they say a doctor and a nurse, that means they must all be present. When they say the managing director or the secretary, that means one of them. So you have to understand what the law means. So shall versus may. Shall imposes a duty and it's mandatory, whereas may provides discretion. Avoid ambiguity. Never use and or is at causes, as it causes uncertainty. Example, a police officer shall not arrest a person unless they state the reason. So circumstances and conditions, use when or where to state the condition. Example, where a vehicle is unregistered shall not be driven. Use if the expression requirements. Example, if taxes are unpaid, penalties shall apply. So basically that's drafting, because they always bring that draft a penal section on this instance. So when you're drafting a penal section, you have to consider that there must be a punishment and also the offense, but also there must be a person, and when will he or she be liable. So numbering of provisions in legislation, so they must be very well numbered according to sections, and keep it short and clear. And also we can have subsections in case you want to add on that. So also gender sensitivity, you must make sure that it's gender sensitive. You don't say that a female, you say any person, you get. Or you don't say that the chairman, you say the chairperson. Those are some of the mistakes that people make. So that's basically how you do what you draft a law, because they also usually ask these things. They give you a set of facts and they tell you to draft, and that's how basically you go about it. So let us look at the language of legislation and typography. Avoid unnecessary legalese. Drafters should use plain, clear, and concise language. Avoid archaic expressions like aforesaid, herein, after, or provided always, which confuse the reader. So avoid, example, avoid the said party shall herein after be referred to as the respondent. Use the party shall be referred to as the respondent. Then technical terms, use technical terms, e.g. fee simple habeas corpus only when they are necessary for legal precision. So write for the intended audience, draft rules for the public, write clearly for non-experts. So then good English is essential. So when you're drafting, you must also consider good English. So in other things, topography, you have to consider the font and layout. Always Times New Roman is preferred. Then the spacing, paragraphs, then hyphens and dashes. So a hyphen join words, e.g. 10,000 shillings note. Then also have punctuations and symbols, margins and page layout, and block quotations. So basically, these are the things you have to consider when you are doing what? When you're drafting a legislation. Because some of the legal writing past papers, they have given you facts, and they want you to do what? And they want you to draft. So basically, that's how you go about it. So usage in enumeration paragraphs, use semicolons, use to separate distinct provisions for clarity. Example, no person shall sell food that, then you put a semicolon, A contains harmful substances, is unfit for consumption, or is adulterated. Then commas for interrelated ideas. The interest in shares is transmitted by death, lunacy, or bankruptcy. So techniques for gender neutral drafting, repeating the noun instead of using a pronoun. Avoid gendered pronouns by directly referring to the noun. Example, an employer shall ensure that the employee's safety at work. A director reaching at the age of 80 shall resign the director's office. So instead of saying that the director reaching the age of 80 shall resign his office, you say the director's office. So use his or her instead of his. And this is what most of the dictionaries do. They use his together with her. But those things of saying that his refers to her, they stopped, I think, in the Bible. Then recasting sentences in the plural. Plural sentence naturally use gender neutral pronouns. Use relative clauses. Avoid pronouns by rephrasing the sentence and using participles. So avoid demeaning or patronizing language. So equal respect in terms. Use plural terms when referring to men and women. Gender inclusive occupational references. Avoid man words for general references. Don't say man includes woman. Traditional terms, gender alternative, chairman, chairperson, fireman, firefighter, fisherman, fisher, housewife, housemaker, mankind, humanity, manpower, workforce, repairman, maintenance worker, men at work, people at work. So these, don't use words which are not gender sensitive. So explain key elements in letter writing. So when drafting letters, whether for personal or professional purposes, understanding purpose, audience, and evidence is essential for clarity and effectiveness. So the purpose of writing a letter or memorandum guide is the language, tone, and format used in the document. The letter may be 1. To inform, giving clear and concise information. 2. To persuade, trying to convince the recipient to take action or adopt a particular viewpoint, or to engage. So when you're writing a letter, you have to take into consideration 1. The purpose, the audience you are addressing to. Understanding your audience is crucial, whether you are addressing a colleague, superior, or institution. Knowing their expectations influences the tone, language, and structure of your letter. Then evidence, you must back up assertions in your letters with appropriate factual evidence. This could include true facts, accurate data or descriptions, supporting authorities, legal statutes, case laws or precedents, and critical reading, reviewing the facts carefully to ensure relevance and accuracy. So key formatting elements in letter writing, we have a letterhead. If absent, create one that includes the addresses and contact information. So these ones are always by law firms. Then reference. The reference serves for record keeping purposes, helping you to trace communications. Then salutation, adjust based on formality. Use dear sir or madam or dear, depending on the audience. Then date, the letter must be dated, and content structure. So here I drafted an example of a letter of the Minister of Constitutional Affairs, and headed past the bar and company advocates. PO box, you begin with your address, then after that you put our ref, then 6th December 2024. the Honorable Minister, Minister of Constitutional Affairs, then Dear Honorable Minister, then improving legal education in Uganda. So you write from there, then the content, then you as face free, you sign and then pass the bar and company advocates, carbon copy if necessary. So key formatting and style considerations, font. So use standard fonts like Times Roman numerals or Arial size 12. Then line spacing, single line spacing is typical. Then margins, ensure left and right margins are 3 to 5 centimeters. Consistency, be consistent in formatting such bolding headings. Tone, maintain a formal tone, especially in professional correspondence with institutions or government officials. Then summary of key elements in memo writing. A memo is an internal communication tool used within organizations or institutions. It is typically concise, focused on a specific issue, and not used for formal external communications. A memo must include the following elements. Purpose. The memo should clearly state its purposes, explain the reasons for writing. 2. Essential information. This includes the subject matter, which should be highly summarized. Then 3. Tone and length. The memo should be brief, neutral, and respectful in tone. Then actionable steps. It should clearly state and any actions required of the recipient or indicate if no action is required. Then formatting. You must make sure that you clearly format your memo, and it must be having a heading, date, signature, and also a clear structure. So here we have an example of a memo as the director of the Road Development Center. It's an internal memo. So to Director Road Development Center, carbon copy Deputy Director Academic Affairs from your name as a student. Then ref, subject challenges students are facing at campus. So this memo is to bring you attention some of the key challenges that students at Road Development Center are currently facing. So they include the following. So then you put them and then propose the actions, and then action required, then signature, your name and title. So basically a memo and an opinion almost the same in their structure, but what differs is that a memo is always an internal document, whereas an opinion is an external document. Then we have other various communication forms and their purposes. We have a loose minute. A loose minute is less formal internal communication within an organization, and is typically used between colleagues or offices to inform, remind, or provide updates on matters that need attention. For example, if you have a case coming up for hearing, you can use a loose minute. And basically, a loose minute is an internal communication between members of the same institutions. So a loose minute to carbon copy from and date ref. Subject follow up on pending document submission. As simple as that. Action required, kindly submit the document by 9th December 2024. Then have notices and demand letters. Notices are typically formal written communication to inform parties of important relevant actions, often following structural requirements. Then demand letters are written when an action is required from the recipient, usually demanding payment or compliance with a legal obligation. Key features of statutory notices: purpose and then content. So statutory notice of intention to sue. So basically, I think we drafted the statutory notice of intention to sue. It must be, of course, it can even be having parties in the matters of the intended suit between Patrick Evra versus maybe Kamuntu Joseph. Then notice of intention to sue. Take notice that the name or intended to institute a suit against you in this court at a location in which they will seek this relief. The facts constituting the cause of action arose on this date as follows: that we signed the contract on this date to deliver milk. I delivered the milk and refused to pay. Therefore, I intend to go to court. The value of the subject matter of the intended suit is 10 million. So you are therefore hereby notified to pay all else which shall take you to court. Then you sign it and date it from the law firm. Then statutory demand notice. This one is the one which is demanding for payments. For example, it can be to or from dear. Then demand notice, like they will have been doing. Then reply to a demand notice. When reply to a demand letter, maintain a respectful tone and be clear about the position you are taking. If you dispute their claims, state the reasons politely and refer to any supporting evidence or documents. So reply to the demand letter to the one who served you, then from, then dear. I refer to your letter dated in which you have demanded payment of 1 million for the outstanding loan. After reviewing the details of the claim, I would like to inform you that the claim is contested due to state the reasons why the debt is disputed, e.g. overpayment, error in calculations, etc. As such, I request that you provide further documentation or clarification of the alleged debt so that we can proceed to resolve the matter amicably. I remain committed to addressing the issue as soon as we receive the requested details. Please feel free to contact me should you have any questions or require additional information. Yours faithfully, your name. So reply to a notice of intention to sue. When responding to a notice of intention to sue, it is important to acknowledge the notice, provide a response to the allegations, if any, and indicate whether or not you are prepared to settle or proceed to court. Reply to the notice of intention to sue. 2. Name of the plaintiff and the advocates of the plaintiff, and their name of the plaintiff. Refer to notice dated indicating your intention to sue in relation to briefly mention the issue of breach of contract. I wish to inform you that we acknowledge the receipt of your notice. We are currently reviewing the matter and we intend to respond fully within the time frame allowed under the relevant provisions of the law. In the meantime, I would like to explore the possibility of an amicable resolution of this matter without the need for litigation. Should you wish to discuss this further, please do not hesitate to contact me. Yours faithfully, then your name. So that's basically how you reply to those letters. Just keep it simple, clear and straightforward. Then also we are looking at writing a legal opinion. So this part looks at key aspects of drafting a legal opinion and opinions and memoranda. One, you have to consider the tone. Legal writing should be clear, formal and objective. Avoid jargon, Latin phrases or overly legalistic language. The tone should match the audience's knowledge and expectations, ensuring clarity without assuming prior expertise. Then audience, tailor your language and tone based on whether the audience is professional or non-expert. Always clarify the problem, maintaining objectivity, and avoid personal opinions or judgment language. Then evidence. Legal opinions should be supported by solid evidence, considering both supportive and opposing views. It's essential to present facts logically and objectively, showing awareness of relevant laws and amendments. And then critical thinking. Effective legal writing involves questioning sources, assumptions, and interpretations. Legal professionals should think critically, evaluating evidence and considering how their judgments affect others. Then legal opinion versus legal advice. A legal opinion evaluates the legal implications of a situation, while legal advice gives specific recommendations. Then 6, the art of thinking. Critical thinking is vital in legal writing. Professionals should question their approach, seek deeper understanding, and ensure arguments. Then questioning. Critical questions such as purpose, information quality, assumptions, implications, and consistency guide the process of writing and help avoid errors in legal reasoning. So these are the things you must take into consideration when writing a legal opinion. 1, your tone. 2, your audience. 3, the evidence you have. 3, you must critically think for is it a legal opinion or is it a legal advice? Then also the art of thinking and questioning. So here I'm writing a legal opinion to the Uganda Law Society on challenges facing the law professionals in Uganda. So it's to the President of Uganda Law Society, PO Box, from your name, your title and your firm, then date. Subject, legal opinion on the challenges facing the legal professionals in Uganda. Introduction. I have been asked to provide a legal opinion on the challenges currently facing the legal profession in Uganda. This opinion addresses key issues impacting practitioners and the functioning of the legal system and outlines potential measures for improvement. The challenges identified stem from various sources, including legislative and regulatory frameworks. the evolving demands of client and also the ongoing need for professional development within the legal communication. So I looked at the key challenges: limited access to legal education, slow and insufficient judicial process, and lack of adequate legal information. Then I came here, I put recommendations, and then after that I concluded. And please feel free to reach out for any further clarification or additional discussion on this matter. Yours, name, your title, your firm, and contact information. So basically that was it for what? For a legal opinion. But these things have the same structure. What is different is the purpose they serve. A legal opinion is an external document, whereas a legal memo is an internal communication. So summary of drafting transactional documents. Key aspects of drafting: understand the area of law before drafting. So drafting transaction documents includes like sales agreement, partnership deeds, a mortgage, a loan agreement. All those ones are transactional documents. A sales agreement. So understanding the area of law before drafting, it is essential to understand the relevant area of law to ensure that the document complies with the legal requirements and avoids illegalities. The purpose of the module: equip students with skills to draft and analyze transactional documents, manage transactions from the initial stages, and understand the role and responsibility of transactional lawyers. Audience and client expectations: tailor the documents to meet the needs of the clients as well as the legal requirements. Key elements of transactional documents: there must be recitals, provide background or context to the document, attestations, that is where it needs to be attested, warranties, conditions, general clauses, and miscellaneous clauses. Then planning and structure: formalize yourself in the legal area involved and the document's features, identify key principles and the desired legal effect. Then document layout and topography: this includes how we're going to paragraph it and also lay it out. Then formatting: introduce and the table of contents for longer documents, structure documents, division, and proper organization. So these are the things you consider when you're drafting transactional documents. The purpose of the document, the law applicable, the audience, the key components of the transactional documents, which include recitals, attestation, warranties, and conditions, then planning and structure, paragraphing, subparagraphing, all those things, then document layout and typography, then formatting. Examples of transaction documents: we have contracts, sale and purchase agreement, employment contracts, lease agreements, memorandum of understanding, shareholder agreements, non-disclosure agreements, loan agreements, and partnership agreements. Those are examples of transactional documents. So that was it for legal writing. It has been a pleasure as well as a blessing. I really wish you a happy new year. Let us meet next year. Please, if you have not subscribed, subscribe, because next year we shall be covering both workshops from the January intake as well as the September intake. So it's going to be a very good resource tool which is going to help you to answer your oral exams, because I believe we have covered in detail almost everything. So happy new year. If I don't post any video for this year, happy new year, and may 2025 become the best year ever, where we shall all pass the bar course and continue to enroll as advocates. May your dreams come true. Please, God loves you. Your body is your temple. Make sure that you protect it.